FDD. And for those of you who don't know us or haven't been here before, we're a national security think tank, and welcome. For those of you who do know us, welcome to our new premises. We specifically got this new office just for this book event, so we're very pleased. But actually, I think it is our first major event, so we're very pleased, in particular, to have my good friend and colleague, Ord Kittry, launch our new space as well. We also are having this event hosted by our Center on Sanctions and Illicit Finance, which is a center that we launched about 14 months ago, along with our colleague Juan Zarate, who's the chairman of that center. And the center has been involved for many years in economic sanctions and economic warfare, and we've spent many, many years working on this issue. And I only tell you that because it was, in fact, almost a decade ago that Ord Kittry came to me and said, gee, Mark, you know, we should start working on sanctions together. And so I've had a decade-long relationship with Ord, and Ord has taught me over that past decade the critical importance of having research that is defensible, that is high integrity. And Ord is also one of those people who not only does meticulous research, but he is a master at turning research into action. And in fact, that has really become FDD's motto, as a think tank turning research into action. So I'm very grateful to Ord for everything that he's taught me and for inspiring not only our sanctions work, but for very much the business model that FDD has. I want to ask you, by the way, please silence your phones, other electronic devices. And I want to talk a little bit about why we think this topic is so important. But I think Jim Woolsey, who's our chairman, who's here, really summed it up best in the foreword to Ord's book when he said that, quote, the failure to engage with lawfare systematically while our adversaries and potential adversaries are doing so is not only a missed opportunity, but it's also increasingly dangerous. And he called on all U.S. and allied policymakers and lawyers to read Ord's important book and heed its call to action. For me, having read the book, there's so many wonderful anecdotes and vignettes and great recommendations in the book, but something that really stood out to me was Ord's description of the power of lawfare in the case of the legal case against Iran and its acts of terrorism. And I know Steve Perlis is here and others who've been working on this issue. This is something that FDD is very much committed to. And Ord explains in his book that when the Marine barracks were bombed in 1983, that Caspar Weinberger, who was then Reagan's defense secretary, insisted that the United States never had fidelity on the attack. And Secretary George Shultz, who's part of FDD's Leadership Council, he criticized the lack of American response, but he claimed, quote, we may never have the kind of evidence that can stand up in an American court of law, but we cannot allow ourselves to become the Hamlet of nations, warring endlessly over whether and how to respond. So Ord notes, actually, that it was in an American court of law, almost 20 years later, on May 30th, 2003, that Iran was finally held accountable for the Marine barracks bombing. And on that day, Judge Lamberth, actually, who we're honoring next month at FDD's Washington Forum for his remarkable work, he ruled in the Peterson case versus Islamic Republic of Iran that Iran was responsible for the Marine barracks attack. And Ord notes that in the book, in efforts to collect on the judgment against Iran, almost $2 billion in Iranian government assets in a Citigroup account were frozen by a federal court in Manhattan. Just about a month ago, FDD filed an amicus brief in the Supreme Court case where the Peterson case was heard, and I had the honor of attending that case, the first time I've ever been to a Supreme Court case, and it was really remarkable. And the judgment is due out in June, so I think we're all waiting anxiously for that judgment. But it's a very potent example of the importance of lawfare. Ord goes on in his book to talk about other examples of lawfare. He deals with how China uses lawfare, how Israel uses lawfare, how the Palestinians and Hamas use lawfare. And particularly, Ord spends a lot of time talking about the boycott, divestment, and sanctions movement, which for me is important because not only is it lawfare and economic warfare against an important American ally, but it has to be understood in the broader context of how American adversaries are using economic and legal warfare against the United States and our most vulnerable allies. So with that, I want to introduce Congressman Ted Deutsch. Ted. Ted is a good friend of FDD's. He's a good friend of all of ours, and he's long been a leader in the effort to combat Iran's malign activities, nuclear, ballistic missile, terrorism activities throughout the Middle East. And Ord also talks about the role of then State Senator Ted Deutsch in Florida, how Ted actually mobilized the Florida State Legislature and forced Vitol, which was the largest energy trading company in the world at the time, that supplied 60% of Iran's refined petroleum imports, to choose between working in Iran or to work in the great state of Florida. And Ted put them to a choice. Vitol made the decision to discontinue those refined petroleum exports. And then when Ted was elected and became Congressman Ted Deutsch, he led efforts in Congress to expand on the Iran sanctions, which really punished the regime for its malign activities. So we've been very honored to work with the Congressman and his staff over the years, and I'd like to first introduce you all to Congressman Ted Deutsch.
Thanks. There you go. All right. Mark, thanks very much for the introduction, and I want to thank FDD for the great work that this organization does under the leadership of Cliff May and Sharon Woolsey and Mark Yu. We've enjoyed many productive conversations together, and your contributions to the work that I do now on Capitol Hill have been invaluable. I'm really proud of the relationship. I'm really pleased to have the opportunity to spend a few minutes with you today. I've known Ord for a number of years now, and it's great to get a chance to publicly commend him for his work. I first met Ord when I was a Florida State Senator looking for ways in which we could impact national and international security at the state level. And for those of you who are familiar with Florida, you will know that Tallahassee is not typically a hotbed of international security and foreign affairs. At the time, Congress was just beginning to ramp up the use of financial sanctions as a way to halt Iran's nuclear program. This was a time when nearly every major international energy company was still operating in Iran, generating billions of dollars for the regime to fund its weapons program. In 2007, Florida became the first state in the country to pass legislation to divest public pension funds from companies doing business in Iran's energy sector. As a result, over $1.2 billion of Florida's pension money was pulled from those companies, and dozens of states began to follow suit. And from those early days of the divestment campaign in Florida, we realized that we had the power to use these financial sanctions and banking sanctions to effect change. In the year after the passage of Florida's divestment law, the Swiss oil company Vitol was looking, as Mark said, to build a $125 million fuel depot at Port Canaveral. At the time, they supplied about a quarter of Iran's fuel. And we decided to leverage Vitol's interest in Florida by pursuing through the legislature and Governor Christ to pressure Vitol to stop doing business in Iran. And the choice was clear, as Mark pointed out. It was an important choice that they needed to make, whether to continue to do business in Florida or whether to do business in Iran. And Ord, I must say, was instrumental to us in helping us to work through that approach, and I'm grateful for his contribution. By the time that I got to Congress in 2010, the pressure on energy companies was so great that you either do business with the U.S. or with Iran that nearly every major energy company wound down its operations there. Now, I'm proud that Ord chose to include our efforts in Florida in this book about the use of lawfare. And I'm proud of that because this has become such an important weapon that we have, and it's one that can be effective and that does not put at risk the lives of American soldiers. Now, whatever you think of the Iranian nuclear deal, and I was opposed to it, it is clear that economic sanctions drove Iran to the table. That was clear. And whether it drives them to give up their nuclear ambitions remains to be seen. We saw the power of uniting the international community to stop buying oil from Iran and to cut off Iran's access to the banking system. We're starting to face more and more acts of lawfare, and we're dealing with them in Congress every day. In the wake, just a couple of examples, in the wake of 2014's Operation Protective Edge, we grappled with how to counter one-sided and false claims against the IDF. As the Palestinians were attempting to get the UN Human Rights Council to call out Israel for war crimes, as they had done with the outrageous and disastrous Goldstone report, and to launch investigations of alleged Israeli war crimes through the International Criminal Court, Congress, the United States Congress, unanimously passed a resolution to condemn Hamas's use of civilians as human shields. And as Ord discusses in his book, Palestinians have been dogged in their use of the UN system to attempt to redefine the process of seeking statehood. By gaining observer status at the General Assembly, now for the purposes of joining the international agencies such as ICC and UNESCO, they are defined as a state, which they then use in their attempts to seek legitimization at the Security Council. Now, as you know, the United States has responded to these attempts by defunding these specialized agencies that accept Palestinian membership. In recent months, the BDS movement, again, the BDS movement against Israel has gained attention on Capitol Hill, as it has all throughout our country, as we attempt to find new and creative ways to convince those that boycotts of Israeli companies in the West Bank, those that bring hundreds of jobs to Palestinians, it's always important to point out, are misguided. The BDS movement has attempted to bring action in European courts against Israeli companies for war crimes. And while we have yet to see that level of action here in the United States, we are actively attempting to take steps to ensure that U.S. policy continues to stand firm against BDS. Many states, including my state of Florida, have adopted legislation preventing contracts with those companies who engage in boycotts. This was a piece of legislation that our legislature just passed in its most recent session that just ended. At the federal level, the U.S. Trade Facilitation and Trade Enforcement Act of 2015, which is the massive trade and customs bill, contains provisions designed to oppose boycotts and similar economic warfare against Israel. Now, as Ord points out in his book, many countries are becoming adept at using lawfare. And I think it's really important, and I think this is why this meeting and Ord's work is so vital. It's really important that the United States do the same. Just as we have a national defense strategy, we should be crafting a lawfare strategy to complement our military policy and our foreign policy. So I commend Ord for shining a light on this growing practice. I hope it will lead to greater action and involvement from all parts of this town here in Washington, particularly my colleagues in the House. I want to congratulate Ord on the launch of his book. I want to thank everyone at FDD for supporting this effort, and I especially want to thank everyone for allowing me to say a few words today. And Mark, should I turn it to Juan? Back to you. I will turn it back to Mark, as I always do. And I appreciate everyone. Thanks so much for letting me come by.
All right, so we're going to start the panel. I'm going to turn this over to my friend, colleague, Juan Zarate. I'm sure many of you know Juan. Juan was the Deputy National Security Advisor for Counterterrorism in the Bush administration. He was also the first Treasury official who really set up the Office of Terrorism and Financial Intelligence. And he's a great mind on these issues, a wonderful guy, and a senior counselor at FDD and chairman of our Center on Sanctions Illicit Finance. And Juan, I'll turn it over to you.
Thanks, Mark.
Thank
Appreciate
you.
it very much. Welcome, everybody. Hope everyone's doing well. I've been looking forward to this event for a long time, and I've been pushing Ord to get his book out for a long time because the book is so important. The work strategically is critical, and Ord is a real treasure. And I want to thank Cliff May, Mark, Chairman Woolsey for the support that you've given not only to Ord but to this realm of work and strategy, which has been so critical, and which FDD in many ways has helped pioneer. We're going to do this in very informal fashion, but what we want to do is give Ord a chance to frame the discussion. And then I will tell you, we are incredibly honored to have a panel of not just great experts, but great characters. Everyone on the panel here, to my right, appears in Ord's book. And Ord's book is seminal not just because it tells the history of lawfare, but it tells great stories in particular about these three individuals and their work, and then lays out why this is so strategically relevant. So what I like to do is just briefly introduce the panel, give you a minute of my thoughts, and then turn it over to Ord to kick us off. Ord Kittry, as you know, is a senior fellow here at FDD. He is a tenured professor at Arizona State, the law school, so he's a Sun Devil. The tan doesn't reflect it, but and has long been an expert on issues of lawfare, litigation, Middle East, national security law, and was a longtime lawyer at the Department of State. And so brings with him not just great academic credentials, but obviously great experience. To his right is Nathan Lewin, known to his friends as Nat, a legend actually in this field. Has been working in this space for 45 years, both within government at the Solicitor General's office and then in private practice. Has litigated before the Supreme Court more times than I can even count. I think it's probably close to 30 times with great effectiveness, and really a pioneer in this space, thinking through how to use the law for purposes of national security. To his right...
You're going to write my eulogy, I trust.
No, sir. No, sir. There's more work to be done. More work to be done. To his right is Lisa Lewin, not only a great lawyer in her own right, but also the daughter, so the scion of this great family. She and Nat obviously run Lewin and Lewin, and the book articulates and lays out the great work that they did in the Boehm case with respect to the Holy Land Foundation for Relief and Development, which was in many ways a seminal case that held Hamas accountable for their terrorist financing support and laid the groundwork for other important litigation, which we can talk about. And then to her right, yet another legend in the space, Steve Perlis. Steve, a real champion of terrorist victims and terrorist victim cases, made his sort of greatest mark in the Peterson case, which has been litigated, holding Iran accountable for the bombing of the U.S. Marine barracks in Beirut, an incredibly significant judgment and a precedent-setting case. And Steve is really an innovator in terms of terrorist victim lawsuits. And so you've got sort of the pantheon of practitioners and thinkers in this space before you. And so I don't want to take up any more time. But let me just say this about this field. The law is a realm where we work with evidence, we work in argumentation, and we work in the context of judgment. All of that is a realm in which we can bring justice to America's enemies, but also clarity to what is happening in the national security space. And this realm, as Ord puts it, sort of this new weapon of war, takes place in a variety of places. It's happening in the courtroom, which our panelists can speak to better than anybody. It happens in boardrooms and in the financial landscape. It's happening in the context of regulations and financial measures that are now a part of the landscape. And when we talk about the law and lawfare, we're talking about a tool of strategy, as well as an asymmetric tool that's being used by a variety of state and non-state actors. And so when Representative Deutsch talks about the need for a strategy, I think we couldn't underscore that more, and I think this is the point of Ord's book, which is this is now a domain that we have to take into consideration as a strategic tool unto itself, and which, frankly, America's adversaries and adversaries of our allies have realized very centrally is a key part of power. Because at the end of the day, lawfare is about legitimacy, it's about narrative, and it's about affecting the environment around issues of national security import. And so without further ado, let me turn it over to Ord to give us a sense of his message in the book, and then we can open it up for discussion. Thank you.
Hello, everybody. Thank you for coming. Thank you to FDD, and especially Cliff May and Mark Dubowitz and Jim Woolsey for their support of this book. And thank you especially to Aaron Blumenthal for organizing this event. It's a pleasure to see both so many new faces and also so many old friends from all different stages of my career. I'm particularly excited to be up here with 5 of the leading attorneys whose lawfare work is highlighted in the book. Representative Ted Deutsch, who's featured for his exceptionally cutting-edge work in the Florida state legislature, pressuring companies to stop doing business with Iran. That work was remarkably effective, thanks to his work at the state level and work at the federal level by Mark Dubowitz and others at FDD. Within a year or so of us identifying the major suppliers of refined petroleum to Iran, all of them had dropped out of supplying refined petroleum to Iran. In past decades, you would have had to achieve that with destroyers off the coast of Iran, risking bloodshed and escalation. They all pulled out without the US having to fire a single shot. Also, as was mentioned, Nat and Eliza Lewin, whose work on the Boeing case helped shut down the Hamas fundraising network in the United States. There was a robust Hamas fundraising network in the United States that was funding the killing of American citizens in Israel and elsewhere. Again, without firing a shot, with clever lawyering, Nat and Eliza Lewin and one or two other attorneys helped shut that network down. And then, of course, Steve Perlis, whose lawsuit brought justice to the victims of the Marine barracks bombing in Beirut when the US government wasn't able to bring justice, and whose work on the Lindy v. Arab Bank case very recently, which resulted in a $1 billion settlement, set a powerful precedent that if a bank, in that case Arab Bank, it's the name Arab Bank, provides financial services to a terrorist group, the bank can be forced to compensate the terrorist group's victims. I have heard again and again in my discussions with bankers, especially in the Middle East, but also elsewhere, how this is going to lead to a very big change in the way they do business. They are not going to be providing financial services to terrorist groups and their state sponsors anymore, thanks to that case that was brought by Steve and his colleagues that resulted in a $1 billion judgment against Arab Bank for their work supplying services to Hamas. And finally, Juan Zarate for his leading role in developing and implementing the US government's financial lawfare campaign against Iran and its nuclear program. It's no accident that 3 of these 5 are featured for their lawsuits brought as private citizens. And a 4th, Ted Deutsch, is featured for his work in a state legislature. Lawfare is a weapon that can be and is wielded not only by national governments, such as that of China and the US, but also by state and local governments, by militant groups such as Hamas and the Islamic State. Yes, as the book describes, the Islamic State is waging lawfare against the United States, believe it or not. It's also being waged by peaceful NGOs such as FDD and by individual attorneys such as those up here. The book is designed to be both an analysis of lawfare and a call to action. Lawfare needs to be waged with care. The risks of the US waging offensive lawfare include the risk of undercutting US preeminence in sectors such as international finance, where the US leverages that preeminence to wage lawfare. And there's also a risk that some US lawfare might set precedents that could be used against the US by adversaries. Nevertheless, lawfare's increasing power and prevalence should be to the advantage of the United States, with its exceptional number and quality of talented attorneys. While the US does have more sophisticated lethal weapons than do our adversaries, our advantage in sophisticated legal weapons has the potential to be even greater. Lawfare deployed more systematically and adeptly by the US government could reduce US and foreign casualties and save US taxpayer dollars by supplementing or replacing the use of armed force as a tool for achieving some significant US national security objectives. It's important to keep in mind, for some foreign leaders, seizing their assets can be much more damaging than dropping a few bombs and killing a few of their soldiers, about whom they may not care very much. Lawfare can also be invaluable against targets such as China and Russia, with regard to which armed force cannot be used because it's not worth the escalation risk. However, as the book discusses, while China has formally adopted and implemented lawfare as a major strategy, and while Israel has created a special office to address lawfare, the US government has thus far failed to either develop a lawfare strategy of the sort referenced by Congressman Deutsch, or to create a mechanism to systematically wage and counter lawfare. As a result, many of the US's most effective and creative lawfare practitioners today are private sector or other non-governmental attorneys, people like Steve, Nat, Eliza, and Juan these days. I hope the book will help inspire the US government to approach lawfare with a much higher percentage of their creativity and sophistication. Thank you.
That's great, Ord. Nat, let me turn to you and ask you, given that you've been in this space for so long, you've thought about it, you've litigated these issues, what is lawfare from your perspective, and how has it evolved? I mean, a gatekeeping question here is, how do you even define lawfare, which Ord does well in his book, but how do you think about it as a practitioner and somebody who's been involved for so long?
Okay, let me first, to begin with, kind of clarify that I have not been for years involved in this field. I basically, as you said, litigate cases in the Supreme Court, white-collar criminal defense lawyer. My introduction to this field was the Boyne case. It so happened that I was traveling to our home in Israel, in Jerusalem, and this was about 1997, 1998, and a neighbor told me that I should please meet these nice American citizen parents who had come on Aliyah to Israel and whose son was killed at a bus stop at Beit El. I did. I met them. And they said to me, is there anything we can do under American law? We're American citizens. Our son was an American citizen. The guy who drove the car that killed him has confessed in a Palestinian court that he was doing this for Hamas. So I did what a lawyer should be doing, I guess. I went back to America and I looked at the law books. And there was a statute, 18 U.S.C. 2333, which said that you could sue, an American national could sue for injuries that are caused to him by an act of international terrorism. A terrific statute. It said you could sue in a U.S. district court, you could recover treble damages, you could recover attorney's fees. There was one gap in the statute, and the gap was, who can you sue? Can you only sue the guy who pulls the trigger and commits the act of international terrorism? And I said, that can't be right. You have to be able to sue the people who aid and abet by financing it. So I had to persuade a law firm that I was a member of, a terrific law firm, Miller, Cassidy, LaRocca, and Lewin. I was the only Jewish name partner in the firm. People would say to me, Lewin, you argue cases in the Supreme Court, you know, you do all kinds of fantastic things. You teach. I taught at Harvard. I teach at Columbia. Why are you the last name in that law firm? Miller, Cassidy, LaRocca, and Lewin. And I would say, you don't understand. Most of my clients read from right to left. But the fact is, my partners, who were very patient with all kinds of crazy lawsuits I would bring, said to me very justifiably, how are you going to finance this lawsuit? That's a major problem. I want to talk about it in a minute. But how are you going to finance this lawsuit? You sue the Holy Land Foundation, and we got substantial documentation that the Holy Land Foundation was funneling money to Hamas. You sue the Holy Land Foundation, they're going to hire the top law firm. They hired Aiken Gump. How are you going to finance this? Well, luckily, my daughter Aliza joined our firm just around that time, and she became absolutely intent on, we had to file a lawsuit. And it turned out that there was $1 million or more sitting in the court in Chicago, of all places, in which that had been seized from a fellow by the name of Salah, who had gone over to Israel and was handing out money for Hamas to terrorists and families of suicide bombers. So I sued in Chicago, because I persuaded my partners that with $1 million sitting there in the court, we ought to be able to recover some of it. They said, with Aliza pressing, they said, okay. We sued them the day before the statute of limitations ran. 1996 was the event. 2000 is when we sued. 4-year statute of limitations. Who did we draw as a judge? I knew nothing about trying cases in Chicago. Who do we draw as a judge? A judge by the name of Lindbergh. So I asked my friends in Chicago, tell me about Judge Lindbergh. And the universal response was, you have drawn the worst federal judge in Chicago. This guy comes out of the state court, And he only knows about hit and run accidents and medical malpractice suits. And his rule was that you have to have a settlement conference with the parties present within, I don't know, 2 months of the time that a complaint is filed. And I'm thinking to myself, my clients are in Jerusalem. This is a $600 million suit that I brought. This case is not going to get settled. But the judge says you have to settle it. You have to have a settlement conference. So a partner of mine from Miller Cassidy, Rock and Lewin, comes out with me to Chicago, and I'm going to tell the judge there can't be a settlement conference because my clients live in Jerusalem. The other side is murderers who have murdered their son. We're not going to have any settlement. The judge says, settlement conference, September 28th or something like that. I say, September 28th? That's between Rosh Hashanah and Yom Kippur. I'm going to be in Jerusalem. There's no possibility we're going to have a settlement conference then. Well, my partner had contacted a bail bondsman in Chicago because he was sure that the judge was going to throw me in jail because I wasn't going to have this conference. But the judge blinked, and he said, when is your client ever going to come to America? It turned out they were going to come visit some family in November. Well, the judge says, settlement conference in November. This was the most memorable conference I have ever had. We sat in an office in Chicago with Salah, with a guy by the name of Stanley Cohn. Some of you may have heard the name. He was in jail. He was representing all the terrorist organizations and Hamas and various other terrible people. And we sat around that table, and I said, well, I'll go down from 600 million to 200 million. And they said, well, what we'll do, we'll settle this case. We'll publish an ad in our magazine in memory of all the victims of violence in the Middle East, and we will name Boehm, David Boehm, as a victim. I said, that's ridiculous. Anyway, in the course of the conference, Salah says to my client, Israel is responsible for the death of your son. We will not stand for this. We know where you live. He says, we know where you live. What does that have to do with the conference? You know what that means. Anyway, ultimately, the case ends up going through various stages in the Court of Appeals. Amazingly, the judge who first agrees with us turns out on another appeal to reverse a judgment that we won with the help of Steve Landis, who's a phenomenal lawyer in Chicago, who we recruited for this case. We end up with a $156 million judgment, which all the legal journals say is the largest, at that point, one of the largest judgments of the year. Of course, we collected very, very little of that because there was nothing left in the Holy Land Foundation treasury because Holy Land Foundation funds were being used to pay Aiken Gump of an outrage, you know, in terms of defending against our lawsuit. But the bottom line was that we did get that judgment. We got good law out of the Court of Appeals for the Seventh Circuit sitting in bank. And the Boehm case has become the kind of thing for which I'm called, you know, a character in a history of all this. I mean, you know, this all ought to be turned into a movie. I mean, I'd love to see who they would pick, you know, to play me in a movie of this kind.
Robert De Niro.
Yeah.
That's a good one.
Anyway, my point, just to get to the point of all this, and I don't know whether it answers your question. I mean, the book is a marvelous, absolutely compendium of all sorts of, the whole issue of lawfare from all aspects. The one thing that I've seen that's missing, not so much in the book, but in terms of American reaction to this whole problem, is the American legislatures, whether it's the state legislatures or the Congress, do turn sympathetically to the question of what you do with American law if you're a victim or there's a victim of some kind of international terrorism. It does not really turn to the question of what does one do with regard to foreign law, the International Criminal Court, all sorts of other things. We read about the fact that Shimon Peres travels someplace and there's a danger that he's going to be arrested. What's going to be done? And to me, an obvious answer is for the Congress to say that whenever Israel or some Israeli is threatened or is a defendant in a foreign jurisdiction, the United States Congress, not the Justice Department. I don't trust the Justice Department. I don't trust the president. Aliza and I handled the Jerusalem passport case, which we lost in the Supreme Court, and the administration was against us on the question of whether Jerusalem is in Israel. I don't trust the State Department. I don't trust the Justice Department. I trust the Congress. And if Congress passes a law that says that if any Israeli or anybody who is opposed to terrorism from the Israeli perspective is prosecuted in any way in any foreign jurisdiction, the United States will hire a lawyer, one of these marvelously qualified attorneys that you talked about, to represent the interests of the United States, either as an amicus or as representing the party that is involved in that foreign lawsuit. The United States Congress should recognize that foreign countries and foreign jurisdictions are using lawfare. And you cover the fact that they do that. But the question is, what's the remedy in the United States? And there is a remedy in the United States, and the remedy is with the Congress. For Congress, whether it's through the House Judiciary Committee or the Senate Committee or some congressional committee, not the Justice Department, not the State Department, but a congressional committee to appoint and pay for whatever attorneys are needed in the foreign jurisdiction to represent the foreign defendant or the interest that is opposed to terrorism in that foreign jurisdiction. And that's a gap, I think, that exists now that I think can be cured by congressional legislation.
Fantastic. Liza, can I ask you to sort of jump from Nat's points with respect to not only where lawfare is going, but what some of its limitations are, both given the fact that you do have other actors using legal action in a variety of ways against the U.S. and against Israel and against our allies. Where do you see this field going as you look forward?
So I think there are a couple of difficulties that we face, and Ord mentioned some of them in the book. One of them, as my father talked about, is financing. You know, when it's come to the private sector to try and bring some of these lawsuits or come up, these cases drag on for a long, long time, and they are very expensive, and the individuals can't finance those. So that's a problem. Another problem is that, quite frankly, it's challenging, sophisticated legal issues, and it's I think requires a group of legal minds that are ready to try and think creatively and think outside the box. You know, when it came to the Boehm suit, you can imagine where, I mean, we ended up surviving. The Holy Land Foundation, the others filed a motion for Rule 11 sanctions against us when we brought the case, saying this case was absolutely so outrageous. And if you think about it, what we were saying is here were charities in the United States and think tanks in the United States who we said should be held civilly liable for damages to the victims of terror for an act of terror that occurred 6,000 miles away, that they didn't turn around and direct. They didn't say you should go shoot at this bus stop. They didn't send the money over specifically for those guns, and yet we're saying, no, but just the mere fact that you encourage this kind of behavior, you should assume that at some point there may be an American standing at that bus stop, and therefore you should be held civilly liable for damages. Well, that was a bit of a stretch of that law, and yet we were ready to take that gamble. And I remember thinking, you know, it was after we filed the suit before 9/11, and after 9/11, our oral argument in Chicago was set for less than 10 days.
25th of September.
The 25th of September, exactly, 2001. So it was just after 9/11. And aside from the challenge of reaching Chicago at that point and flying out there, it also became apparent to the judges on the court that this was no longer just a private matter between the Boymes and these charities, but this legal theory could be used by others, by the victims of 9/11 against those who had been supporting it. So they asked, the judges asked the Department of Justice to file an amicus brief in the case. And in November of that year is when they did, and I used to say, well, it went from being Nat Lewin's novel legal theory to suddenly being a legal theory that now the Department of Justice endorsed. But it takes people who are ready to push that envelope, and they're not necessarily out there. And the other problem, one more, is that the people who are using this are often people who are not following international law, who are not the law-abiding citizens. And we don't think that way. We don't operate that way. And so we have found ourselves so often on the defensive, trying to respond to that rather than trying to think how to use it offensively, because those who are using it offensively are using it to try and evade what's the accepted practice. And we're not used to thinking that way. So we have to try and figure out, well, how can we use it in a way that is within the parameters of the law? And that's challenging.
Steve, can you give us a couple of anecdotes from your experience and your thinking in terms of the realm of lawfare and what this all means?
Sure. You know, I apologize in advance. I'm the least entertaining of your panelists. I went off to teach at the University of Michigan Law School a few years ago, and as I was headed out the door, my wife quipped, "Speak long, dear. Law students are terribly sleep deprived." You know, let me start by saying that, you know, Nat and I share one common experience, and it really is a wonderful one. We both have our children working for us, and you know, my son is a more recent graduate from law school, but he's now working for me, which is you know, truly a blessed, as you know, a blessed experience. I will say, I owe a lot of that to Ord, because when my son was a law student at NYU, he clerked for Ord long distance, and you know, Ord would send him writing assignments or whatever you sent him, and anyway, he got trained up very well. He's a pretty good young lawyer, managed to pass the bar on the first go around out in California. You know, people ask me, do you have any regrets in all of this about things you haven't accomplished? And I do have one regret. I regret not being able to convince the executive as an institution that lawfare is a real weapon that benefits the United States as a nation. And I'd like to talk about a few exceptions to that, so that you can understand how it works, or when it works, how really well the process advances. Before I do that very quickly, everybody's talked about how long the litigation runs. It isn't just long, it's very, very complicated. And in that sense, let me say, I get a lot of credit for other people's work, because when I start these projects, I build litigation teams, and I am more a successful builder of teams, if you would, than what I would call, you know, superstar lawyer running down the field by himself. And I see Richard Heidemann, who is a member of several of my litigation teams. His partner, Noel Noodleman, is here. I don't know if I've missed anybody else who's been on litigation teams with me, but I thank you. I mean, in part, I'm sitting up here because I try and surround myself with people who do really good work like your firm does. You know, people think of my firm as having an adversarial reputation with the executive. And from time to time, that's true, I suppose. Yeah. But it isn't always true, and the exceptions are when lawfare really works. And I'd like to run through a few of those very briefly. There is a joint venture that we have running with the Department of Justice. It's with the U.S. Attorney's Office in New York for the seizure of a Manhattan skyscraper, 650 Fifth Avenue, that the Iranians were using as a money laundering facility. That seizure works, and I hope it stays stuck together. We're up in the Second Circuit now waiting for for an opinion. The good news is that, worst case scenario is that'll go back for a trial rather than be resolved on motion for summary judgment. But that works because the private bar and the Justice Department really treat this as a joint venture, and we each uphold our end. And as I say, we managed to short circuit several years of trial process by working together and to get that turnover order really orchestrated on a joint venture basis. There is no adversarial relationship between our office and the U.S. Attorney's Office in Manhattan on that project. Another good example comes out of your days at the Treasury, and if you'll forgive me, I'll give credit to Stu Levy instead of to you. He was your boss at the time. But people talk a lot about this $1.9 billion that we managed to seize in New York. The turnover order in that case, as people have mentioned, is now up at the Supreme Court. But that whole seizure activity really started as a joint venture between your office and my law firm, where you had certain national goals you wanted to accomplish, which was to choke off Iran's nuclear program financially. Classic Lawfare. You saw this asset in New York that you didn't think you could hang on to yourselves because of the way that asset had entered the United States and the rules governing your activity at that time. So effectively you turned to us and said, you have shorter fences, but you have a bigger playing field, and maybe this asset is on your playing field. Maybe it's outside of our fences, but inside of your shorter fences. And you provided the raw intelligence data to us under seal, and then we effectuated the seizure of that asset. That's a wonderful example of lawfare being done on a public-private joint venture where you brought your strengths, which was the collection of intelligence, financial intelligence data, and we brought our strength, which was the playing field, if you would, and our ability to surround that playing field. And don't misunderstand, I'm playing the game to win. But even if we lose, we took $1.9 billion of Iranian money out of circulation at the time that the U.S. was really trying to choke that off in order to get Iran to the table. Win, lose, or draw from the government's perspective, that's already a win. Yep. From the private perspective, we need to finish up to put it in the win column. Another good example, actually Mr. Gibbs is here from the State Department, is a joint venture we did with the Legal Advisors Office, and there were really three groups involved in that joint venture. It was time for Mr. Gaddafi to ante up for his role in a lot of terrorist activities. At the time, I was representing the LaBelle discotheque bombing victims and victims from several other attacks. I believe Richard was my co-counsel in several of those pieces of litigation. Jim Kreindler was representing the Pan Am family, and John Schwartz, who I think has now retired from the Legal Advisors Office, was there. And the three of us created this little, if you would, we created this little law firm, a public-private law firm. Doesn't exist on paper, but in practice we were going round and round together, and we triangulated the Libyans, and after 5 years of settlement negotiations with Libya, 90 days after we put together our little public-private partnership, the Libyans threw in the towel and the really serious settlement discussions started. It goes to show you how the State Department and the private bar, when the State Department feels so inclined, can work together to create the rewards of lawfare, if you would, for the nation as the whole and victims as individuals. And finally, at the trial level, we had a case called Gates versus the Syrian Arab Republic. And Gates and another gentleman named Armstrong were personally beheaded by Zakawi, who had founded AQI, Al-Qaeda in Iraq. And we believed that AQI had been materially supported by the Syrian government at that time. The Defense Department had its own issues with the Assads and AQI, because by the time this case was launched in the direction of trial, AQI was out killing a lot of servicemen on the Syrian-Iraq border. So for the first and only time in terror victim practice, the executive was providing us with witnesses. In that case, they were DOD witnesses. There were a lot of security concerns associated with that. The DOD witnesses testified not in person but by secure video link. They testified under pseudonym. But we got through all of that. And the judge, Rosemary Collier, understood. I mean, it went unsaid. Everybody wanted the Syrians done for this activity. The private bar for our reasons, and the Defense Department for its own reasons, and we won $122 million compensatory damage award for 2 families. It was the largest compensatory damage award for that scale litigation in the history of the Republic, and it remains so today. In the end, we found some Assad money out in Chicago, and I think we blasted about $82 million away from them and have distributed it to those 2 families. But make no mistake, the reason the number is so robust in that case is the federal judge said, the executive is here. The executive is trying to help make this happen. This is lawfare, again, practiced on a joint venture basis between a federal agency and the private bar, and the message was very clear to our federal judge. The DOD's participation really helped make that the robust success that it is.
Well, I hate
That's
to
the good
rain on the
news.
parade, but the fact is, I mean, we had terrific cooperation from the Department of Justice with regard to the civil side of the Boeing case, but a clear gap in terms of what the Department of Justice does, where they are clearly delinquent, is the criminal prosecution. People are killed in Israel, in Judea and Samaria, American citizens, where there is clear provision under the U.S. Criminal Code that that's a crime in the United States to kill an American citizen abroad, and certainly in a terrorist act, and there hasn't been a single indictment, not one indictment brought by the Department of Justice against the people who admit killing American citizens in Israel or in Judea and Samaria. Before I brought the Boeing case, I testified before a congressional committee. The guy who drove the car from which David Boehm was shot and did it for Hamas admitted in a Palestinian court that he had done it and that he was doing it for Hamas. And I said to the Department of Justice, and I wrote to them, why don't you indict this son of a bitch? Why don't you? Whether you try to extradite him or not is another question, but make it clear that any of those people are violating American law by committing a criminal act abroad. There was no answer. And today, just a couple of weeks ago, victims, people who are families of people who were murdered, American citizens murdered in Israel, where the victims are known, where the perpetrators are known, and the Department of Justice does nothing. Zero. They don't care. Why doesn't the criminal division of the Department of Justice indict these guys?
I'm not going to stand here and be the apologist for the executive. I talked about the few instances when it works. Most of the time, it fails. Most of the time, we have a dreadful relationship with the executive. Let's focus on a circumstance where it worked and circumstances where it fails involving a very relatively small group of terrorists. We'll just focus on Palestinian terrorism for a second. Richard Heidemann and I have a case called Baker. And Baker involves a Libyan-sponsored, or Libyan and Syrian-sponsored Palestinian terrorist who shot 3 U.S. nationals in the head and tossed them out of an airplane while the aircraft was sitting on the runway in Malta. that Palestinian terrorist was indicted and convicted in Malta, served 7 years in Malta, was released without notice to the United States. He fled to Africa. The FBI engaged in a rendition, found him, engaged in a rendition in Africa, brought him back to the United States, prosecuted him. He is doing, I think, 3 life sentences in the Maxi prison out in Colorado Springs. And I sent Richard out there, because he's my trial guy, I sent Richard out there to interview him. And what we discovered when we interviewed him is that that attack was facilitated by the government of Libya when the weapons that were used in the attack were smuggled through the Athens airport in a Libyan diplomatic pouch. The fact that the government was willing to chase this Palestinian terrorist to the end of the earth and bring him back had the later effect, years later, of providing us with really valuable information which later let us make out a case against Libya. At the same time, had that individual hijacked an aircraft and had that aircraft been on the runway in Tel Aviv, in the same circumstances, there would be no prosecution. So on the Palestinian side, in that world of terrorism, what you see is if the Palestinian terrorist engages in an act of terrorism outside of Israel, the Justice Department hunts them to the end of the earth, just like they did with Rizak. If that same attack were to have occurred on Israeli soil, there is no criminal prosecution. And that dichotomy is unconscionable, it's unjustified, and it's indefensible.
It goes further. It's even just indicting, even if they don't go to the ends of the earth. About
Right.
2 months ago, I think I saw that the Department of Justice indicted the woman who they felt was holding Mueller hostage.
Right.
And they said, they made it clear she's in Iraq now, and she'll probably never be able to be brought to the United States, but they wanted to make sure that if she were ever going to try and travel, there was this outstanding indictment. They have not yet, even though at this recent hearing on Capitol Hill, they talked about how they were very aware that there had been Palestinian terrorists who were released as part of the Shalit deal who had American blood on their hands. They claim that they are reviewing and researching it, even though there are terrorists who were tried and convicted and sentenced and were serving sentences in Israeli prisons. Those folks are now walking free. One of them is a TV celebrity in Jordan, and they haven't even had the courtesy, if you want to say, to indict any of those individuals here under the same theory.
All right, fantastic, lots of energy. We're going to open it up now for Q&A and discussion. We're going to, just so you know the sequence here, we're going to do Q&A for about 15 minutes. Then we're going to have a reception and book signing. So we're encouraging you to buy the book. This is part of the process.
Everybody can have one copy.
Oh, okay, got it. Oh, no need to buy. Okay, I'm sorry.
We're giving them out.
Oh, I'm sorry. I didn't know that. Well, I'm sorry.
FTD button.
It's like Oprah.
Even better. Well, great. So the reception and pick up a book. Even better. But you sign it, right?
Yes.
Perfect. Okay. Why don't we do this? And while you're raising your hands and thinking of questions, let me take a prerogative and ask one quick question of Ward. Given your research, where are the best, let's say, 2 examples of where lawfare is being used against U.S. and its allies? Is it BDS and what China's doing, or what are the 2 best examples you can give us in summary fashion as to where lawfare is being used against our interests?
Sure. Thanks. So, as I say in the book, really the superpower in lawfare today is China. The People's Republic of China has adopted lawfare as a major component of their national security strategy, and they're waging lawfare in a very sophisticated fashion in various fields, including the cyber law arena, the non-proliferation arena, the maritime law arena, the aviation law arena, the space law arena. They're doing this in a very sophisticated fashion. You know, I tell people that this is, and it is, the first ever English language book focused on lawfare. But interestingly enough, it's not the world's first book focused on lawfare, because the Chinese have already published. The People's Liberation Army Press themselves have published 5 or 6 books on lawfare. They are taking this very seriously. And to me, this is ironic because the US has better lawyers, smarter lawyers, more lawyers than the Chinese do. And it seems to me that we need to be taking what the Chinese do more seriously. We need to be waging lawfare more seriously against them. We need to be developing better defenses against their lawfare. That chapter of the book, chapter 4, includes dozens of recommendations for what the U.S. can do differently with regard to China and lawfare. Another example of lawfare being waged against the U.S., and I see a number of my friends who are military lawyers around the room, and this is something that the Islamic State does, something that the Taliban do. What they do is they use the U.S.'s greater allegiance to international law against us. They will hide amongst civilians and fire at U.S. positions from amongst civilians, right? I mean, by firing from amongst civilians, they're violating international law. But they don't care because nobody ever holds them accountable for violating international law. They're doing this in order to draw us into violating international law. And the U.S. is so careful about not violating international law that we put ourselves at a grave disadvantage. There's some great quotes in the book from Charlie Dunlap, former Deputy Judge Advocate General of the Air Force, who is the father originally of the concept of lawfare. And he talks about how the Taliban, for instance, by surrounding themselves with civilians, create a legal fortress that is as powerful as if they had the most sophisticated anti-aircraft weapons surrounding them. Because once they do this, surround themselves with the civilians, the U.S. won't attack. And they use this against us. And one of the recommendations in the book is that we have to do a much better, a much more sophisticated job of countering this, in part by holding them accountable when they violate the law of armed conflict, the law of war. And that's something that we haven't been doing thus far, and I think we need to.
And we articulate our positions and our rules of engagement and the near certainty standard, and all of this then gets taken into account. Absolutely right. All right, let's go to questions. Please identify yourself. Right here, please. And use the microphone.
Hi, Mike Kraft. I was in the State Department Counterterrorism Office for many years. My portfolio included dealing with legislation. And I want to pick up on something Ord said about the U.S. government sometimes worrying about precedents. I was involved when we opened up the Foreign Sovereign Immunity Act to allow suits against countries that are on the State Department terrorism list. And frankly, there was a dispute between my office, the Counterterrorism Office, and the Legal Advisor's Office. Maybe David remembers more of it, because we wanted to do it, and the people in legal advisors were worried about precedents. Our perspective was not just to be engaging in punitive action to get allow court actions and rewards, but also as a deterrent. To make the terrorists and the country supporting terrorists think twice about it, about conducting acts. And it's very hard to measure, of course, if they decide to think twice. But I'm wondering if you touched on this with the military. As I recall, there's been some items in the press about threats of lawsuits, actions against American military men because of what they're doing overseas. Can you cite any other precedents on this that in terms of where the U.S. government has been worrying about bad precedents?
Ord, you got that?
Sure. So, so the question had to do with bad precedents and ways that lawfare is being used against the United States. You know, one interesting example. There's a lot of talk. There's been a lot of talk on this panel about how lawfare is being used by the Palestinians against Israel. And there's an interesting story in the book and also in the sort of handout that I gave you about how the Israelis were so concerned about the Palestinians hauling Israel before the International Criminal Court that the Israelis released 78 Palestinian terrorists with blood on their hands to buy simply 8 months of respite from the Palestinians going to the International Criminal Court. Now, interestingly enough, and nobody seems to realize this, the U.S. has been hauled already before the International Criminal Court with regard to allegations that the U.S. engaged in war crimes in Afghanistan. And the U.S. is not a party to the International Criminal Court. This is odd, and from an international law perspective, it seems to me outrageous that the International Criminal Court is investigating the U.S., which frankly has a very good record of compliance with the law of war. The International Criminal Court is investigating the U.S. despite the U.S. In fact, the U.S. has not made itself subject to the International Criminal Court. It has chosen not to become a party to the International Criminal Court. Now, the Bush administration took all of this very, very seriously. The Bush administration and people like Juan took a number of steps to make sure that U.S. Soldiers wouldn't be hauled in front of the International Criminal Court. This administration, and I don't mean this in a partisan way, but the record reflects, and it's in the book, that this administration, and it's been confirmed to me by senior people in the government, this administration has just about done nothing with respect to the fact that the U.S. is being hauled before the International Criminal Court. This is the sort of very bad precedent that we need to be aware of. You know, the moment we have international courts, which are made up of judges from a lot of countries who completely flout the international rule of law, the moment we have international courts second-guessing what we're doing, it's going to be much more difficult for the U.S. to do what it does overseas in terms of supporting democracy and fighting our enemies. This is something that we need to cut off at the beginning, and it's simply not being done with regard to the International Criminal Court's moves against us with regard to Afghanistan.
Yes, here. Lady.
My name is Mana Alami. I'm a non-resident fellow with the Atlantic Council. I focus on radical groups. I'm very new to the lawfare domain, the field of lawfare. My question is about Hezbollah. In December of 2015, President Obama enacted the act, Anti-Hezbollah Financing Prevention Act. And up until now in Lebanon, we haven't seen any implementation of this act. We know that Hezbollah is in government. We've seen only punctual implementation of this act. For example, a few people related to Hezbollah or to Hezbollah MPs have seen their accounts closed. However, the accounts were immediately reopened after a complaint was sent to the governor of the central bank. So my question is there a time span for the implementation of such an act? And when the whole banking sector in Lebanon is exposed to something like that, how strict are these? How strict is this applied?
Steve, do you want to take this? I'm happy to try to answer, but is this something you've looked at from your vantage point? Or anybody on the panel for that?
I'll try and start. And I don't have a very good answer for your question. I can tell you that the Arab bank case, I think sets, at least on the civil side, and a lot of your question goes to the government side, and I can't talk about the government side. I don't speak for them, and they certainly don't speak for me. Sometimes we don't even speak to each other. On the civil side, I think what you see in the Arab bank case really helps define where private practitioners want to take lawfare. In the middle of the Arab bank case, and by the way, Ord put a settlement number out there, and I have to issue a disclaimer there. I disassociate myself with anybody's public speculation as to where that case has settled or is settling. It's sealed, and for the record, I disassociate myself with your comment. I have no comment about what that number is.
So noted.
In the middle of the Arab bank case, when it was clear that it wasn't going very well for the Arab bank, and I won't say that the outcome was preordained, but that most, as I joke when I teach at William and Mary, sometimes I say, if I were a betting law professor sitting in Vegas, well, in the middle of the Arab Bank case, where betting law professors sitting in Vegas weren't betting on the Arab Bank, and that case was really about the laundering of dirty Saudi private money, not Saudi government money, through New York to Hamas. I got a call from a European reporter. Some dirty Saudi money had found its way to a bank in Egypt, and the bank in Egypt, rather than send it along to Hamas as its Saudi depositor asked that it do, instead convened a press conference and said, we have received this money, we have received this instruction, we are not going the way of the Arab Bank. We are holding this press conference today to announce to the world that we are sending this money back to our client depositor in Saudi Arabia so that we don't suffer the same fate as the Arab Bank. That's how lawfare is supposed to work in the banking industry. My hope, 10 years from now, we'll look back at this and see if it's right. But I think that the shockwave from the Arab Bank case has been so substantial in the banking community that my hope is a lot less dirty money will flow through major financial institutions, again, through the United States and back to terrorist organizations like Hamas, irrespective of what the real number is for that settlement. By anybody's expectation, if you look at a case involving 150 different victims, it's a big number. And the strength of that number and how it's been reported in the press helps deter future acts of money laundering, as we can see from this bank in Egypt. The role of the press in all of this is kind of interesting. I'm going to be in Rome at the American University of Rome on the 13th of April, participating in a one-day symposium out there about the role of the press in all of this and its effect on litigation. The Italians haven't coined the term lawfare yet, but I think by the end of my participation, maybe some of them will start to speak that way. Does that help answer your question? Little bit. Okay.
There's no question that law is intended to temper the environment and to force the Lebanese banking system to make some harder choices about doing business with Hezbollah. How that plays out in terms of enforcement, I think we'll just have to see. Or do you want to ask a question of maybe a panelist or two, just real fast? Yeah,
a couple things I wanted to point out. One is with regard to the Arab Bank case. The Arab Bank case is one of my favorite cases. And as I tell the story in the book, the Israelis were the origin of the intelligence that was used in the Arab Bank case to win that judgment, that settlement of around $1 billion as reported by the press. How they ended up deploying it was very, very interesting. The Israelis got a hold of intelligence that Hamas money was moving through the Arab Bank, one of the biggest banks in the Middle East. And they said, what are we going to do with this intelligence? And the first thing that they tried to do, in I guess 2003, 2004, the Israelis went to the Ramallah branch of the Arab Bank, and they said, here are the account numbers, and we want all the money in these accounts. At gunpoint, they said to the clerks, and the clerks handed over the money. It was about $9 million. It was terrible PR for the Israelis. Look, the Israelis are robbing a bank. Also, the challenge is, that you go and some of those accounts, were overdrawn that day. Some of them didn't have the money that they were supposed to have in it. So this was a big disaster, and the Israelis said, wow, what can we do with this intelligence that is more effective? And what they did is they turned that intelligence over to the US government, and they turned that intelligence over to US litigators. And that intelligence was then part of what led to this judgment, which resulted in a $1 billion settlement on behalf of Arab Bank. And that shows you the power of lawfare. You take the intelligence, you go to the bank, you get $9 million at gunpoint, and you get hammered for it in the press. You turn the information over to litigators and to the Treasury, you get 100 times more money with none of the criticism. That is one of the powers, one of the incredible things about lawfare. There are a lot of great stories in the book. I don't know if Steve has time, or maybe in response to another question. One of my favorite stories in the book has to do with Hezbollah and how Steve managed to track down, and this, as I understand it, this story was told for the first time in this book. As we mentioned, with regard to the Marine Barracks bombing, the US government, Cap Weinberg, has said, we'll never have the fidelity on who did it. Well, Steve Perlis managed to track down the builder of the bomb and had him testify in US court. And I think maybe that's a story worth briefly telling.
Never happened. First, he testified by deposition. First of all, it's a bit of an exaggeration. It was a very big bomb. You have to understand, this is a tractor-trailer truck-sized bomb that blew doors off of buildings 1,500 yards from the epicenter of the explosion. So he was one of a team of senior bomb builders. But yes, at the end of the day, we did send a team to the Middle East. We did find this guy. We did get him into a hotel room. We did get a very detailed deposition debena essay from him about Iran's involvement in the building of that bomb. And that much is known publicly. Who he is and precisely what he said has been turned over to the U.S. intelligence community, and it remains under seal in the federal courthouse. And that's probably all I'm going to say about that. For the military people in the room, there are two looking forward at lawfare, because it's not just about what you wrote about, it's what your next book is going to be about. And if you want to look forward to the next book, there's a couple of cases for military personnel that I think are going to be very interesting going forward over the next 10 years or so, because that's the life cycle of these kinds of cases. One is Fritz versus the Islamic Republic of Iran, and the other one is Foley versus the Syrian Arab Republic. They both stand for the same underlying principle of lawfare, and that is that no nation on the face of the planet has the right to kidnap, remove U.S. servicemen from the battlefield, and while they are in POW status, engage in extrajudicial killing of those servicemen. Each of the servicemen plaintiffs in those cases falls into that fact pattern. For some, they were Syrian-backed militias. In other cases, it was really a directed Iranian attack. In each case, the Department of Defense issued a POW medal to those servicemen. So they really are, from the Defense Department's perspective, extrajudicial killings of servicemen who are removed from the battlefield. I think from a lawfare perspective, that is one of the most exciting things that I have going on right now. It's a great principle of law to establish. It has enormous deterrence. It has potential for enormous deterrence effect going forward. And I will tell you, that's an important, it hasn't been discussed today, but that's an important part of what we do. If you talk to, and I think this is common among all terror victim families, they look at the death of their loved one as senseless, as meaningless. And if you can establish a bright line rule of law, like what we're trying to do in the Fritz and Foley case, when it's over, those families can look back and legitimately say something positive happened as a result of the death of my loved one. It wasn't meaningless. May have been senseless, but it's no longer meaningless. There's a real rule of law there going forward that might save somebody else's life in the future.
That is very definitely the case with the Boyms, I will tell you. You know, that was their feeling, and they realized going into it, as we told them, that they may not recover funds, but we may succeed in shutting down the fundraising in the United States for Hamas, which has been severely curtailed as a result of it. And then for them, one of the most meaningful things has been that they then established the legal precedent that enabled the Arab Bank case and the other cases that have followed, and that for them has very definitely, I think, given significant meaning to them for the loss of their.
Yeah,
I don't think we ought to stop and quit at this point without pointing up a very important caveat and a condition to all this, and that is the Boeing case. I have to tell you, successful as it was, and I spoke about it at some event at Fordham Law School in New York, and it turned out that in the audience was a lawyer in New York who subsequently decided that the theory that I used in the Boehm case could be used against American charitable organizations that provided funds that were used across the Green Line. And that lawyer deliberately took the theory of the Boehm case and brought a lawsuit in the Southern District of New York against 5 American charities that give money both inside and outside the Green Line, in which he made allegations that the money was being used against Palestinians living in Judea and Samaria, or even those living within the borders, the Green Line of Israel. He brought that lawsuit. We, Aliza and I, represented the 5 organizations in the Southern District of New York. We got the case dismissed in the Southern District of New York, and the dismissal was affirmed by the Second Circuit. Now, the amazing thing is, not only did this lawyer follow Boehm, but he in fact told me, he sent me either an email or a note or something saying, I have followed your strategy in Boehm in bringing this lawsuit. And the other amazing thing is, the day after the lawsuit was filed, before we were even returned, I got a call from Al Jazeera saying, Mr. Lewin, what do you say about this lawsuit that was filed in the Southern District of New York against 5 American charities who get 501c3 status and send money across the other side? I hadn't even known about the lawsuit. And yet he had asked Al Jazeera. I refused to comment. Aliza and I, as a matter of strategy, said we are not going to publicize this lawsuit. We did not disclose or talk to any press about that lawsuit until after the Court of Appeals for the Second Circuit affirmed the dismissal. Now, many of you may have read probably that just the other day, some lawyer here in Washington filed some mammoth, crazy lawsuit against everybody from Elliott Abrams and all kinds of organizations, claiming that all the terrorism and all the murder that goes on supposedly in Judea and Samaria and in Israel that harms Palestinians is caused by them and by the 501c3 status, and therefore they're entitled to billions and billions of dollars. I hope that a judge in the District of Columbia, I don't yet represent anybody in that lawsuit, but I hope that a district judge in the District of Columbia sees that this is ridiculous and we can get rid of that lawsuit. But the point is that with all the very desirable affirmative efforts that are being made to combat using Lawfare to combat what is being done in terms of terrorist acts, you have to worry about the boomerang effect.
Fair enough. By the way, Ord,
Real
again,
fast, Steve.
going forward, new things to watch for. We represent ISIS victims, Sotlofs, Muellers. Keep your eye open. We have some thoughts. and they'll become public within the next 2 or 3 weeks, I would think.
Ord, a quick closing thought from you, please.
Sure, thanks. I just wanted to note, you've obviously heard a lot here about lawfare in the Israeli-Palestinian conflict. There's a reason for that. Hamas, Israel, the Palestinian Authority, and their allies are each vigorously waging lawfare, although in different ways. As I explained in the book, much as the Spanish Civil War served as a testing ground for weapons and tactics which were subsequently used in World War II, the Israeli-Palestinian conflict is providing a first look at cutting-edge lawfare techniques that will soon be replicated in other conflicts, including against the United States. Lawfare is a weapon, law is a weapon that can be used for good or bad purposes. Our adversaries are using it against us. My closing remarks, I want to urge all of us, including especially those in the US government, to think about the fact that we need to make sure that we are waging lawfare in as sophisticated and systematic manner as our adversaries. Again, this is an arena in which if we take it as seriously as they do, we will win. We have better and more lawyers. Thank you.
Thank you. Please join me in thanking Ord, Nat, Liza, and Steve. Thank you all. And now go pick up a book, and Ord will sign it for you.
Absolutely.
Thank you.